please.
Thank you. Thank you, Chairperson. I'm pleased to be here today to lend my expertise to the committee as it considers Bill S-215. I'm an associate professor at the University of Manitoba Faculty of Law, and my research expertise is in bankruptcy and insolvency, with a particular focus on the CCAA and Canadian federalism as it concerns bankruptcy and insolvency law. In my opinion, the CCAA and commercial insolvency legislation more broadly is simply not the appropriate vehicle for resolving the financial distress of a public university. The proposed bill is a step in the right direction in terms of precluding university access to commercial insolvency laws and developing a tailored framework for resolving the unique nature of financial challenges at universities. Canada already provides such tailored bankruptcy regimes for certain types of businesses and institutions. For example, insurance companies, banks, securities firms, and farm businesses. And this is in recognition of the fact that there are limitations to a one-size-fits-all approach, and some institutions raise unique concerns or are of too great an interest to the public to have their fate left in the hands of commercial creditors. Commercial insolvency proceedings generally work well when the debtor is a for-profit business accountable to shareholders, but these proceedings are poorly suited to resolving the types of concerns which come up when a public university is in financial difficulty. One example of this is the court-ordered embargo on Laurentian's requirement to comply with access to information requests during part of its CCAA proceedings. Here, the checks and balances ordinarily expected of a broader public sector institution, which is reliant on taxpayer dollars, came into conflict with the narrower financial analysis that guides CCAA proceedings. And it's an example of how the mismatch between the nature of the debtor and the nature of CCAA proceedings gets resolved by applying a commercial lens. This is the effect of undermining the mission and purpose of public universities. The CCAA process is not set up to consider the largely non-financial objectives of an institution of higher learning, the consultative collegial governance structures of universities, the accountability and transparency owed to taxpayers, and it is especially poorly equipped to deal with the particular vulnerabilities of university stakeholders like students. The CCAA facilitates negotiated solutions to business insolvencies, but these resolutions tend to reflect the relative bargaining power of parties who hold formal legal rights. The resolutions are worked out in the shadow of commercial bankruptcy liquidation, which is also poorly suited to university insolvencies. And thus, CCAA resolutions tend to work best for those with experience of the commercial insolvency system and relatively deep pockets. Developing a bespoke process as contemplated in this bill would facilitate a fit-for-purpose university insolvency process, which could address the areas of tension that have been brought up by the Laurentian insolvency. It would also establish the forum for resolving public university insolvency, which I think in itself is an important governance check because it would take the choice of how to resolve this insolvency away from the managers who are unable to manage the university's finances successfully in favor of a more transparent process where all the parties concerned are on more even footing. Thank you. I look forward to your questions.